Today's topic is most important relating to the maintenance. Under which act and under which provision we are entitled for maintenance. So mainly maintenance is going to be ordered by the court. Old age parents, wife who is entitled for maintenance during pendency of the divorce proceeding, maintenance proceeding, or any proceedings before the court, and children, minor children who are entitled, and minor girl is entitled till the attainment of majority as well as till marriage is performed by the parents. So maintenance means that you have to first seek from section 125 CRPC. Yes. Section 125 says like this. Just you, section 125 of CRPC, Civil Procedure Code. Kindly maybe look into chapter 9 and section 125 order of maintenance of wives, children and parents. If any person having sufficient means neglected or refused to maintain, hence they are entitled. His wife unable to maintain herself. He is legitimate, illegitimate, minor children, whether married or not, unable to maintain themselves. Legitimate or illegitimate, who has attained majority, where such child is by person of any physical or mental abnormality or injury unable to maintain itself. This is relating to children is concerned. Then his father, mother unable to maintain themselves. So all of them, they are comes within the definition of section 125. So under section 125, where application should be made, that is main important, jurisdiction is concerned in the official area, that is wherever the civil judge or judicial magistrate first class. In rural areas, they have to file application under section 125 as required to maintain all these persons, and they are entitled for maintenance, interim maintenance also, along with 125 proceeding till disposal of the matter. So in early occasion, in early days, when I have started my practice, only 125 proceeding, the maintenance is filing before the court. That is magistrate court, as well as wherever jurisdiction is required. Then 1984, the family courts are established. Therefore, all the jurisdiction of maintenance, it is transferred to family court, wherever the family court established as per the government orders. So 125 proceeding, what is the benefit in that? The notice which is going to be issued to the opposite party, only the through police. And whatever order going to pass, that executable order through police only under section 125. This is the advantage used to take by the advocates and filing the petition under section 125 against the father, against the husband or son, those who are filing the petition for maintenance. Now, recent judgment, I think you have read over in the newspaper, stating that illegitimate cannot be called. He is also legitimate son only. Whoever may be born through other wife, means other relations, if he is declared as son of the person, so therefore he cannot be called as illegitimate child. So therefore That is the judgment rendered by Honorable Justice Srimati Nagaratna Madam, and now she has elevated to the Supreme Court. Therefore, illegitimate cannot be called. He is also legitimate child, therefore entitled for maintenance. In those days when I have started in CRPC, only 500 rupees limited, because in those days the cost of living and all other things. So therefore 500 rupees has been fixed under section 125. So the court used to order 200, 300, and if another son is available, 400. That's all. No 500 rupees has been started when I was started practice, because then only 500 rupees fixed under section 125. But now it can be granted as per the cost of living, as per the requirement, as per the payment which is drawn by the husband or son. Under section 125, it clearly says that it may be granted based on the proof of evidence to be placed by the claimant who is going to claim the maintenance. So under section 125, it has been relating to the only maintenance, that is the chapter 9. So it can be altered or it can be vary. They have to file necessary application after passing the order. That is 125, it is maintenance order, litigation charges, everything it can be ordered under section 125. If anything he wants to vary, for example, if a husband or son getting salary of rupees 20,000 per month till his attainment of superannuation, now the court has ordered 10,000 rupees to maintain the parents as well as the children or wife. So once he is retired from service, he won't get 20,000 rupees, he may be getting 14 or 10,000 or 12,000 rupees. So therefore, alteration, he can make an application before the court under section 127. That is the procedure laid down under section alteration of allowances, which was granted under section 125. And the executable order also, it is only the magistrate can issue arrest warrant or FLW warrant, fine levy warrant, to recover the money, whatever arrears. Now, what is the penalty under this section? Penalty is lesser, 1 year, that's all. So therefore, if he is, who is affected party, if he is in the jail, automatically that 1 year, whatever the maintenance, if arrears he has not paid, during that period which was ordered, automatically exempted. So that is the main problem in this section. And every year, as per the 125 section, every year you should file a execution petition before the court only. Now, even 11th month or 12th, 13th month, if you are going to file, you have to lose 1 month payment. So therefore, be caution. 125, wherever the order has been passed, it shall be continued only 1 year, and very next year, you have to file another petition if he has not paid whatever arrears is available. So likewise, under section 125, these are the restriction has been made. So my humble request, whether the maintenance under section 125, the jurisdiction available to the magistrate and family court. So they have to issue fine levy warrant to recover the money, or they have to issue arrest warrant to the husband or son, recover money, whichever is available. So under section 125, it can be extended up to one third of the salary can be recovered if the children are available. That is also ordered, it can be ordered under section. And the one question you may depose against me and saying that, sir, if he is not able to earn so much money, whether 125 is applicable. Yes, That is the one formula is there. What it means, if coolie, if he is doing a coolie work, 30,000 rupees or per month, it can be calculated if coolie he is going to get every day earning of rupees 500. So therefore, in that cases, some amount, lesser amount going to be ordered, because based on the evidence only, proof only before the court, what is his earning, what is his liabilities, and who are all the dependents on him, and whether he has neglected the children or wife only. All these things, considerable orders shall be passed by the Honorable Magistrate. So this is under section 125 is concerned, maintenance. It can be enhanced, and alteration and allowances, not only to the husband, but also it is available for the maintenance who are getting from the court. Parents, children, unmarried daughter, and minor children also, they can claim maintenance against the father and or the son. So therefore, my humble request, what is the petition you have to file? Under section 125, you have to file. Before family court, one provision is there. One section is available because family court has to permit to file a petition under section 125. That is, IA should be filed along with the petition under section 125. That is, under section 13 of the Family Court Act, permit the counsel to engage the petitioner before the court. That is the family court. But in Mofsel area, this permission is need not required. They can file before the magistrate court because magistrate is having jurisdiction. So this is the provision is available. Wife can also claim more maintenance by filing a miscellaneous petition under section 127 of CRPC, and she has also claimed to vary the maintenance. If maintenance only 5,000, she is not unable to maintain herself or children. So therefore, she can file for enhancement also. So these are the provisions available under section chapter 4 of the CRPC, and they are entitled for maintenance, and procedure has been laid down to file necessary application under section 125. I think you understood the criminal procedure code provided the benefit to the children, wife, old age parents, and parents are also entitled. Even parents are entitled. They are not attain majority, but they are unable to. They means parents means who are father, mother. They are also entitled for maintenance if the son is neglected. So therefore, 125 CRPC can be used for the purpose of getting immediate execution, immediate recovery of money from the through police only. So this is the provision made under section 125. It can be availed to you. And petition, how to be drafted. So kindly maybe look into first prayer, first application is concerned. You are telling the address of the petitioner, and then marriage, all these things you should mention in this case. Most important case is concerned, the marriage must be proved before the court. Parents should be proved they are the parents. Likewise, even also adopted father is also entitled for maintenance because adoptive father is also available, entitled for maintenance. So all these things available under section 125, and you must disclose how you are living and what are the income of the respondent and what are the expenses of the parents or the wife or children. Likewise, you have to mention in the petition, wherefore direct the respondent to pay maintenance of rupees 5,000, because you have to show your expenses, one para, and another para you must show about the earnings of the respondent. Then only the court can come and give all the benefits to you under section 125 is concerned. So I think you know about this section 125 and 127. So procedure laid down, you can read the chapter 4, because whenever you are sitting in the office or sitting in the court or library, you must read 125 proceeding, that is chapter 9, chapter 9. You should read, and you are entitled for maintenance, who are all entitled for maintenance, and enable them to present the petition before the court. So this is under section 125 proceeding. Now, Hindu law. Hindu law is applicable only Hindus. So therefore, they are entitled maintenance. Now, under section 125 is concerned, father, mother, whoever may be, they are entitled for maintenance. Means Muslim, Christian, or anybody else. They can file application before the court. They are entitled for maintenance under section 125. So what about the Hindu law is concerned? Under section 24, during pendency of the proceeding, any proceeding between husband and wife, any proceeding, husband and wife means restitution of conjugal right, divorce, nullity of marriage, or any petition if you want to file. Along with the petition, you shall file for maintenance during pendency of the suit under section 124. Then, is there any extension for us to file application along with those petitions? Means restitution, nullity, divorce, void marriages, all these petition comes within the Hindu Marriages Act. So therefore, you have to file an application under section 24 only for maintenance till disposal of the case under section 24. The same thing adopted. He has neglected us and he has filed the petition against us. So therefore, we are entitled for maintenance. Wife, she can file straight away. And children also entitled along with the wife. So she has to claim on behalf of children also interim maintenance till disposal of the petition. That is Hindu marriage, sections 24 of Hindu Marriage Act. You may ask me, sir, is there any permanent alimony? Permanent alimony can be granted or not? Yes, it can be granted under section 26. That is section 25. Permanent alimony or maintenance. Now, permanent alimony means you can ask for, sir, I need money, permanent alimony. I don't want to file again and again. I don't want to come before the court if respondent, my husband, going to pay permanent alimony lump sum, that is 50 lakhs, 1 crore towards maintenance, me and my children, or he is going to leave his properties in our favor. That type of permanent alimony also we can claim under section 25 of the Hindu Marriage Act. Interim maintenance is available only during pendency. But along with the section 25, you can claim permanent alimony while disposing of the petition. Kindly maybe grant permanent alimony under section 25. You can add the prayer in your objection statement. That is also available for you. And this is the permanent alimony and maintenance available under section Hindu Marriages Act. I think you understood when we can file. Hindus, he must be a Hindu. That is the law. Because you have to establish, I am Hindu, therefore I am entitled against my husband or against my entitlement. Now, if the husband is living along with Hindu family members, because joint family he is living, when he is entitled for living along with joint family members, also wife can claim maintenance from Hindu joint family income, which is going to be payable to the husband. So that income also you can add along with his earnings by rent, by salary, by coolie work, whatever amount he is getting. So that also. So one problem is there, because this shall be adopted. It is based on your knowledge only. This act and this act. The both acts are your knowledge only. You see, now every employee, what they are doing, getting lump sum loan from his employment, and they are going to deduct. So what purpose he has taken, you should prove before the court. Sir, unnecessarily he has taken money, even though he is getting earning from Hindu family. Therefore, you can ask maintenance, even otherwise, if he has taken the loan amount and his deduction is more, therefore, he is not entitled for maintenance, because some small amount may be granted. So loan, what purpose he has taken, you have to establish before the court only. So therefore, that is also the tactics going to play the husband or son. Since I am not getting money, this amount has taken loan, I have invested towards my parents or towards my so and so. If no material is available, the court can consider grant money as per the cost of living where you are residing. So that is also available under the Hindu Marriage Act. Only two sections, protective section available during pendency, as well as while passing the order, you can claim permanent alimony or compensation in that section. So you have to get these section 24 and 25. You must be remember 24 only interim maintenance pending disposal of the case. So therefore, you have to take advantage of permanent alimony, because intelligently you have to draft. See, when you are asking permanent alimony, you should prove how his income, what is his income, and what are the properties available in his name. All these things you should claim the permanent alimony. Otherwise, it is very difficult for you to say that permanent alimony is not granted and only the petition is allowed for declaring the divorce, marriage is null and void. All these things you should claim intelligently. You have to draft while you are claiming the permanent alimony, because if you don't want to reside along with you, sometime what happened, the wife claim, yes, I want to discuss with him and I want to place this matter before conciliator. Then at Bangalore, BMC, that is Bangalore Mediation Center, under section 89 of CPC, just note down, under section 89 of CPC, every magistrate, every honorable judges, they are having power to refer this matter under section 89 before the Bangalore Mediation Center. There, one conciliator will be, a mediator will be appointed, and private session and joint session, everything is available. For discussion, we can close our issues. We don't want to retain the matter before the court, and it can be decided by way of agreement. That agreement both are signing, advocate are also signing that agreement, and that agreement going to be accepted by Honorable Justice while asking for both the parties. So likewise, we can insist upon honorable judges, sir, this is husband and wife. If I want to continuously lead my life, I want to settle my matter before BMC with a certain condition. So therefore, kindly maybe refer. Your request, definitely every judge is going to be considered. So that advantage also you must take, and as early as possible, give justice to your client. So this is very, very important while you are engaging before the court in such matters, because it is a special issue between the husband and wife. There is a evidence based on only presumption, and the evidence which is going to be recorded as per they are saying before the court. And while cross-examined, we can get out from the mouth of the parties what is the truth. So therefore, direct evidence is not available. So only presumptive evidence is available, and that evidence should be taken into consideration before the court. So my request all of you, while you are dealing the matter, try to conceal the matter between husband and wife, because Hindu woman and Hindu husband, kindly maybe look into that sanctity of the marriage should not be spoiled. At your instance, it may be closed, it may be taken into consideration. Yes, I want to do justice for both parties. Therefore, you take instance, several examples. I have tried my level best. I don't want to file objection. First, I want to refer the matter to BMC, and then I want to discuss with them. If it is not possible, then only I can file the objection statement to the petition. So likewise, you are also extend your help to remain the family intact. So therefore, my humble request to you, when you are coming for practice, you should do that, and justice can be granted to them. The God will say for your earnings, no problem at all. So this is under Hindu law. Now, another one thing, sir, maintenance is also available, Hindu adoption and maintenance. So you see, Hindu Adoption and Maintenance Act, it is also available for you to file a suit, OS suit. Suit also filed or petition also filed under section 22, that is 22 of Hindu Adoption and Maintenance Act, 1956. In that provision, section 22 is available for dependents, and only they should be a Hindu. That is the law. So therefore, under section 22, you can claim saying that we are the dependents, therefore we are entitled for maintenance. And under section 23, amount of maintenance can be granted. So under section Hindu Marriage Act, interim maintenance during pendency of the suit, section 24. Section 25 is permanent alimony. Under Adoption Act, maintenance is concerned, section 22 is available, 25 is available to get the maintenance from the son, husband, those who are our family members. Under any Hindu family is also go before the court against Hindu male person. And old age persons, they are depending upon the son and children. So therefore, they have to also claim under section 23 of Hindu Adoption and Maintenance Act. So I think these are the differentiated under these provisions. At Bangalore, we used to file Hindu Adoption and Maintenance Act only by way of petition. And if it comes before the civil court, you have to file this. These orders are executable. So my humble request, because you must be, once the order has been passed under Hindu Marriage Act or Hindu Adoption Act. So how to execute those orders? That is also main important for you. And you have to consider to execute the order passed by the court. So how to execute? Only by way of execution petition before the court. After passing the decree or passing the order, the execution petition should be filed under order 21 only. Otherwise, it is very difficult for you to get it executed. So one thing we are adopting, nowadays we are adopting before the family court. Once the maintenance has been granted under these provisions, under execution petition we are filing. Along with, we are mentioning section 125 proceeding, recover the maintenance, because it is very difficult to file a execution. And if he has not paid any maintenance amount, then automatically he should be beyond he should be sent to jail, central jail. But at our cost, we have to deposit for his maintenance to while he was in custody. That is bata should be deposited before the court. Then only execution order going to be passed and he is going to send to jail. Otherwise, if we have not deposited amount, no order going to be passed. Only recovery based on the movable properties we can recover. Immovable property, only alienation, that is long process. So these are the provision is available. Executable order under CRPC is concern entirely differ because the police authority, they can execute the warrant. In these cases, if it is executed, he has brought before the court, he shall be sent to the central prison only with depositing our bata. This is the execution orders, adoption, Hindu Marriage Act as well as Hindu Adoption Act. So be remember, this can be passed by the honorable justices, honorable judges before family court. And one thing, the maintenance petition and section 24 and 25 is concerned. These are the interim maintenance in the proceeding of divorce. That is, always petition shall be filed before honorable district judge. District judge authorizes in rural areas senior civil judge. They are eligible to having jurisdiction to proceed with the matter. Only the district judge we are going to place these matters. At Bangalore family court, every court they are all district judges. So therefore you be aware the jurisdiction of filing a petition before the courts and only before the district courts. So this is the under section 24, 25 of Hindu Marriages Act, 22 and 23 of Hindu Adoption and Maintenance Act. Most important, now new law has been introduced. Kindly maybe look into. Enormous power has been given to the Assistant Commissioner today. What are the powers and functions under this provision? The Maintenance and Welfare of Parents and Senior Citizens Act 2007. So under this provision, the Assistant Commissioner is the Assistant Commissioner of Revenue, who is chairperson of the tribunal, maintenance tribunal, that is called as maintenance tribunal. Assistant Commissioner and chairman of maintenance tribunal. It is introduced in the year 2007. So you see, under this provision, the senior citizen they can claim, and one thing you must be remember, those petitions shall be present by the parents only. Recently, one judgment has been passed saying that, yes, advocate can appear on behalf of senior citizen. Earlier, it is not available to us. I have filed several petitions through senior citizen only. So therefore, you have to now make an application and permission you should sought. I may be appeared on behalf of the senior citizen before the tribunal also. So it shall be disposed of within a 6 months because senior citizen unable to maintain themselves, unable to come before the court, unable to wait for long period before the court. So therefore, they can pass the maintenance under section 4 of this, the Maintenance and Welfare of Parents and Senior Citizen Act. I think section 4 is available to us. Section 5, the procedure laid down, how to file the application along with the petition to claim maintenance. Yes, only maintenance, this tribunal is not available. Now you see, if old age persons brought by the sons or one of the son, he got the property from him by way of getting registered document, gift or partition or any document. If he has taken registered document, it shall be cancelled. by way of order going to be passed by the tribunal, that is headed by Assistant Commissioner Subdivision Revenue of Taluka places. It is tribunal. So this power is having Assistant Commissioner. They can cancel the sale deed, the gift deed, even though it was executed 20 years ago, but it shall be filed before the court to cancel this. Because of this, they are enjoying the fruits of my property, because which is gift away to him. Still he don't want to maintain to us. So therefore, it can be cancelled. They can claim before the tribunal also. In this case, no appeal is lies. Very, very important topic. Under this provision, appeal is not available. Except writ jurisdiction, we are going against the order of the Assistant Commissioner or Chairman of the Maintenance Tribunal, which is passed by Assistant Commissioner of Subdivision of each taluka or each district. So therefore, under this act also, you are entitled for maintenance. And you are entitled exclusive powers of cancellation of documents getting executed by the son. This is also most important. Under section 4, you can file before the court and procedure laid down application. Immediately notice should be cast. Within 6 months it can be disposed of, and all these powers are available to the tribunal. They can dispose of the matter within 6 months. So therefore, it is also speedy disposal of. But one restriction has been made. 5,000 rupees immediately going to be granted. That is also available power to Assistant Commissioner. Maintenance up to 5,000 to the senior citizen, either mother or father or both of them alike, each 5,000 to be granted by the tribunal. So, and also cancel the sale deeds, gift deed, everything power has been given, power has been enumerated, and to the Assistant Commissioner, they can cancel it also. So this is very, very, very important topic. Under this provision, section 4 and 5, you can file a petition before the tribunal along with permission seek by the tribunal engaging the advocate, and now it has been permitted. So you can also appear on behalf of the senior citizen. Formerly it was not there. Now the judges, the honorable justices are permitted. The advocate can appear on behalf of the senior citizen because they do not know the legal language or legal practice. So therefore it has been permitted before the senior citizen, before the tribunal, and we are also filing the petition before the tribunal. Now, another provision is available for you under the protection of women from domestic violence. Any Hindu female member, they can approach before the court under the provision of the section, that is DV Act section 20 and yes, maintenance relief under section 20. Now 12 petition you should file. The detailed averments you should be made for protection, for residence, for maintenance. All these should be narrated. Maintenance is concerned under DV Act. That is always we called as DV Act, but it is like this. The protection of women from domestic violence, any female member only they can file. And children are not entitled there, but representing the mother, representing the wife, representing the any family member, if Hindu family member who is aggrieved, who is resided along with them, they are eligible to file application under section 12 of the petition, 12 petition, and under section 20, they can claim maintenance before the court. And 22 is also available for you. Claim exemplary compensation. Compensation you should seek from the court. Now, at Bangalore, what happened? this exclusively jurisdiction, it has been given to traffic court. And order going to be passed, it is appealable under section 29, read with under section 374 class 2 before the family. So this is also very, very important. You see how it has been taken. In my one case, ex filed a petition, mother filed a petition I have fought for in early days. Because what is the violation of domestic relationship? What is the definitions are also there. Now, aggrieved person, who is aggrieved person relating to the marriage? That word is available, that in definition. Under section domestic relationship, any female member, they are eligible to file before the court. That petition should be filed under section 25 for the purpose of protection, for the purpose of granting house, for the purpose of getting lease house, for the purpose of protection to be, direction should be given. I myself and my daughter should be protected from the at the hands of the respondent. So that also application you can file. But maintenance is concerned under section 20 and compensation is concerned under section 22. It can be awarded heavily. In my case, what happened? Mother filed a case before the court stating that my husband was working as a chief manager. He died. He was getting a pension of rupees 9,000, then 12,000. Now, subsequently on his death, I unable to maintain myself. And my husband executed gift deed in favor of 2 children by dividing half of the property. Therefore, those gifts shall be cancelled. I may be put into possession. That mother has been filed. So early occasion when the case was introduced, so several petitions are dismissed because the relationship, domestic relationship is not available, therefore dismissed. So likewise, now it has been clarified, any female member of the family who is suffering from domestic violence lived along with the person who is a member of the family, he is liable to pay maintenance, domestic violence, that is protection, everything you can claim under this act. So therefore, my today's topic is relating to the maintenance is concerned. For interim maintenance, you can get the ex parte order under section 23 of the DV Act. Section 22, damages, means he has damaged my property, he has damaged my all the money he has taken, gold has taken, and you are also having power under this provision of act to recover the gold articles also. Everything, every powers are available under this act to the woman. She must be a family member, Hindu family, or relation with marriages. So that is also available under these provisions. So I think you understood all the applications under these are the provisions are available relating to the marriage is concerned. So my humble request to be draft the petition. If you want, you come to my office, you collect the draft. What are the drafts are available in my office, you can collect. Thank you.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Thank you,
Thank you,
sir.
sir.
Thank you.
I think maintenance is concerned. There is no any question. I think all the provision I have stated for you and you practice. If you want, you note down the decisions. I want to give decisions for you. Section 125 is concerned. Ex parte order can be passed. Srimati Savitri versus Govindraju Rawat, 1986, Criminal Law Journal, 41 into bracket SC, Supreme Court. Ex parte order can pass. And also, recent judgment, 2004, Criminal Law Journal, 4330. This is ex parte order is concerned. So in old judgments, if you want, Note down. AIR 1967 Patna 344. AIR 1964 Criminal Law Journal 1364. These are the judgment. You can get maintenance, ex parte maintenance under section 125. Then Senior Citizens Act, just now I have addressed to you. AIR 2021 Allahabad, page number 45. Issue of eviction order, matrimonial house only. So if he has not paid any money, or if he is unable to pay maintenance, and house is required for you, he can be evicted by virtue of this order. And recent judgment of our own Honorable High Court, Supreme Court, now while passing the interim maintenance in favor of the wife or parents, should not look into about their income, about their property, because it is duty cast upon husband or son. He is liable to pay maintenance. That is also recent judgment has been passed. I'll provide you whenever I required or call me. Now immediately I can't get you immediately. So therefore, these are the sections available for maintenance. These are the provisions are available for maintenance. And any question if you want, I'll answer for that.
Sir, I have one question, sir.
Yes, sir.
Sir, if the wife asks for maintenance from the husband,
Yes.
but husband doesn't go for job,
Yeah.
he stays in his parents' home and it depends on the parents' income. So
Yes.
how is liable to pay?
No, sir. If he is dependent upon the parents, there must be a Hindu family. I think so. Is it?
Yes,
Hindu
yes.
family income is available. It can be assessed from him. Just one thing I want to tell you. Now, what happened during recession period?
Yes.
All the engineers are not entitled for job. They have lost their job. They could not able to maintain their wife. So therefore, income is not available from them. But as per the provision of law, even he is educated, while earning is available, but he has not tried to get job, does not mean that maintenance should not be ordered. Always 3,000 minimum definitely going to be ordered. You need not worry at all.
Okay, fine, sir.
Right.
Sir, my name is Bharath. Like, I have one question.
Yes, sir.
So, referring to Adoption and Maintenance Act, 1968.
Yes.
So, I was looking into the section 18, maintenance of wife. In that subsection 3, they're pointing a Hindu wife shall not be entitled to separate residence and maintenance from her husband if she is unchastity or ceases to be a Hindu by conversion to another religion. So, in your first case, you said like a woman who is having an illegitimate child, she is eligible to alimony. So in this section, can she be not benefited?
Sir, one thing she has converted from other community. So automatically she has to file a petition for under section 125, irrespective of communities. Section 125 available for her. She can claim. And legitimate child or illegitimate child, that word has been removed, going to be removed because there is a direction given to the government. Definitely, shortly it is going to be removed. No, there is no illegitimate. Because father, if he is admitted, he is my son, and his name is appeared in every school records, they are eligible for maintenance till attainment of majority, that is male member, till attainment of till performance of marriage of female, sir.
So what about if she is unchastity?
Huh?
If she is unchastity, so that particularly section says Hindu wife shall not be entitled when
Oh.
she is unchastity.
So therefore she has to go 125, sir.
So his
125
question is, it's like extramarital affair he's talking about.
Extramarital affair, this adultery. You have to
Yeah,
take
adultery.
advantage of divorce only.
Yeah.
But alimony, sir?
Alimony is not entitled by her. Because when she is living adult, she is not entitled. But in my experience, adultery, it is not possible to prove.
It's not a crime, sir, but it's a valid point for divorce.
Yes, valid point. Because you must show some evidence before the court.
So
But
it's
I
never
have
proved, sir, in
just
your experience.
read
Yes,
some
yes.
case
Very strange.
for adultery cannot be bring into the court with a proof. But if a husband is gets to know or believing that he is in, so court also can consider. I'm not sure that, but
Sir, only based on proof of evidence, sir. Because in my career, I think it is very difficult to prove adultery.
Okay, thank you.
So one question, sir.
Yes, sir.
The maximum limit is 1/3 of the total income, right?
Yeah.
Though if it is claimed by both parents and wife, but it is still limited to 1/3, right? And that portion
No.
they have to share it.
Now, not in all cases. If the children are available, definitely the court going to be order 1/3, sir. In my case, what happened? Only one girl is there along with the wife. In my case, what happened? 20% of the salary goes to wife. 7.5% goes to daughter. This type of order has been made.
Okay.
Okay.
Okay, sir. Thank you.
Welcome. I think petition you should be drafted very nicely, neatly. Then only the court can consider your request before the court. Because your submission before the court is also very necessary for the people.
Good evening, sir.
Good evening, madam.
Sir, one doubt, sir. The
Yes.
divorce took place in 2018, sir. It was a mutual divorce. Okay. And during the divorce, wife didn't claim for any maintenance. Okay, maybe due to depression or whatever the reason was, and she didn't maintain, ask for any maintenance. Can she ask now?
Definitely, madam. She can ask. Changes of circumstances. Changes of circumstances. Changes of circumstances means her illness. If met with an accident.
Fine.
So likewise, changes of circumstances. Recent judgment of Honorable Supreme Court under changes of circumstances, it can be filed before the court to claim maintenance.
She said it's not for her, it's for her child, okay, for the education.
No, her child always. Child is not diverse. Child is always entitled for maintenance, sir. Always. Anytime she can file. She can restrict her claim because she may be earning. She can restrict it, but maintenance relating to the children is concerned because growing children. And one thing now in high courts, what they are doing now, for maintenance is separate maintenance going to be ordered till marriage going to be performed for female or till education going to be complete by the boy. So these are the criteria in the high court now. They are strictly following. They are granting the maintenance or compensation in before the court.
Thank you so much, sir.
Welcome. Welcome. Is there any question now? Regarding maintenance, why I have taken burning problem? You have to move the matter where you want. And all these provision is available for you. So you can advise your client. So we should go before the family court, we should go before the traffic court at Bangalore, and we should go before the tribunal. All these provision is available, and you can easily get the maintenance from the courts expeditiously as much as possible.
Sir, one more doubt.
Yes.
Apart from maintenance, does the wife is also like eligible to ask any property that is having on husband's name? Does she have
It is
eligible to ask
under
the share from
Domestic
husband?
Violence Act. There is a provision, shelter should be provided by him. That can be executable order.
Not proper. Property.
The property,
Rented house.
rented house she can claim, or the joint family property she can claim.
No, only for living purpose. Any house she want, husband has to provide a shelter. Husband,
Okay,
instead of
fine.
giving his own property, he can give a rented house also.
Right.
Yes, sir. Is there any question?
No more, sir. Thank you.
Thank you. Because you make use of these provisions, these acts for your concern, and tomorrow you can file a petition before any.
Yes, sir. Thank you so much, sir. It was very informative.
Very, very. Thank you. Thank you.
Thank you very much, sir.
Thank you, sir.
Thank you, sir.
Thank you, madam.
Thank you, sir.
Thank you, sir.
Thank you, sir.